Arkansas is one of the most landlord-friendly states in the country when it comes to rent increases, and the regulatory framework here is about as minimal as it gets. If you manage rental property in Arkansas, you have virtually complete freedom to set and adjust your pricing, consistent with the state's overall hands-off approach to landlord-tenant regulation. As we've discussed in our other Arkansas videos, the state does not have a comprehensive residential landlord-tenant act. Arkansas is one of only a few states that hasn't adopted some version of the Uniform Residential Landlord and Tenant Act, and the landlord-tenant relationship is governed by a combination of Arkansas Code Title 18, Chapter 17, common law principles, and the terms of the lease agreement. This light statutory framework extends fully to rent increases. There is no state regulation of rental pricing whatsoever. Arkansas does not have rent control or rent stabilization of any kind. There is no state statute that caps rent increases, limits the frequency of increases, or requires any government notification or approval before a rent change takes effect. Arkansas's political and regulatory environment is firmly pro-property rights, and rent control has never been part of the state's legislative conversation. Arkansas has not enacted a specific preemption statute prohibiting local rent control, but this is entirely unnecessary because no Arkansas municipality has ever enacted or considered local rent restrictions. Little Rock, Fort Smith, Fayetteville, Springdale, Jonesboro, and every other Arkansas community operate under the same market-based framework. Given the state's political climate and relatively affordable housing market, local rent control is not a realistic possibility. For month-to-month tenancies, the landlord must provide advance written notice before a rent increase takes effect. Because Arkansas doesn't have a specific statutory provision addressing rent increase notice periods, the general rule is that the landlord must provide notice equal to one rental period, typically 1 full month's notice for a monthly tenancy. So if rent is due on the 1st, and you want the increase to take effect on May 1st, you should deliver written notice by April 1st at the latest. The notice should be in writing and should clearly state the current rent, the new rent amount, and the effective date. While Arkansas doesn't mandate a specific statutory form, putting the notice in writing is essential for documentation purposes. In a state where the statutory framework provides minimal guidance, your written records become your primary evidence if a dispute arises. Deliver the notice by a method that creates a verifiable record: personal delivery with acknowledgement, certified mail, or another documented method. For fixed-term leases, the rent is locked in for the duration of the lease term, unless the lease includes a provision allowing mid-term increases. Common mid-term adjustment provisions include escalation clauses, provisions tied to property tax changes, and CPI-based formulas. Without such a provision, the landlord must wait until the lease expires to negotiate a new rent amount as part of a renewal or new lease. When a fixed-term lease approaches expiration, the landlord should communicate the proposed new rent as early as possible. Arkansas doesn't prescribe a specific notice period for rent increases at lease renewal, because the increase is part of a new contractual arrangement, but giving the tenant adequate time to evaluate the new terms is good business practice. If the tenant doesn't agree to the new rate, the lease expires at its natural end. If the tenant stays and the landlord accepts rent, the tenancy converts to a month-to-month arrangement, subject to the 1-month notice requirement for future changes. For week-to-week tenancies, the notice period for rent changes follows the one rental period rule: 7 days notice before the end of the weekly term. Now let's cover the restrictions that apply even in this permissive environment, because having no rent cap doesn't mean there are zero boundaries. Rent increases cannot be retaliatory. Arkansas doesn't have a detailed anti-retaliation statute with specific presumption periods and enumerated protected activities the way many states do. However, courts recognize the common law principle that landlords cannot use rent increases as punishment for tenants exercising their legal rights. If a tenant reports a health or safety violation to a government agency, makes a good faith complaint, or exercises any other legal right, and the landlord responds with a dramatic rent increase, the tenant may have grounds to challenge it. The practical reality in Arkansas is that retaliation claims are harder for tenants to prove than in states with strong statutory presumptions. Without an automatic presumption of retaliation based on timing, the tenant must demonstrate through circumstantial evidence that the increase was motivated by the tenant's protected activity rather than by legitimate business factors. This means that while the legal risk of a retaliation claim is lower in Arkansas than in more regulated states, it's not zero, particularly when the timing and magnitude of an increase make the retaliatory motive obvious. For landlords, documentation and consistency remain the best protection. Keep records of market data, operating cost changes, and any property improvements that support your pricing decisions. Apply increases uniformly across comparable units and avoid any increase that could reasonably be perceived as punishment for a tenant's actions. Rent increases also cannot be discriminatory. Under the Federal Fair Housing Act and the Arkansas Civil Rights Act, found in Arkansas Code Title 16, Chapter 123, landlords cannot raise rent based on a tenant's race, color, religion, national origin, sex, disability, or familial status. The Arkansas Fair Housing Commission, operating under the Arkansas Human Rights Commission, investigates complaints and can take enforcement action. Arkansas's fair housing protections align closely with the Federal Fair Housing Act and do not include the additional categories, like source of income or sexual orientation, that some states have added. However, the core federal protections are fully enforceable, and a landlord who raises rent in a discriminatory manner faces the same federal liability that exists in every state. One unique aspect of Arkansas law that landlords should understand is the state's approach to criminal penalties for certain landlord-tenant violations. Arkansas has specific criminal provisions under its failure to vacate statute that can apply when a tenant refuses to leave after proper notice, but these provisions don't directly address rent increases. However, the existence of criminal penalties in the Arkansas landlord-tenant framework means that landlords should be careful about how they handle the entire termination process if a tenant refuses to accept a rent increase and the landlord decides to end the tenancy. From a practical standpoint, Arkansas's rental market is diverse, with several distinct regional markets. Northwest Arkansas, the Fayetteville, Springdale, Rogers, and Bentonville corridor has by far the strongest and most dynamic rental market in the state. The region's explosive growth has been driven by the corporate headquarters of Walmart in Bentonville, Tyson Foods in Springdale, and J.B. Hunt Transport in Lowell, along with the University of Arkansas in Fayetteville, and a rapidly growing technology, healthcare, and cultural sector. Northwest Arkansas has experienced dramatic population growth and significant rent increases over the past decade. The Bentonville-Rogers area has been particularly active, with rents increasing substantially as corporate employees, vendor representatives, and entrepreneurs have flooded into the region. The Crystal Bridges Museum of American Art and the broader cultural investments by the Walton family have enhanced the region's appeal and attracted additional population growth. Landlords in Northwest Arkansas generally have strong pricing power, and the market supports regular annual increases. Fayetteville, home to the University of Arkansas, has a tight rental market influenced by the university, the broader NWA economy, and lifestyle appeal. Student housing near campus follows the academic calendar, and rents have increased as the overall market has tightened. Little Rock, the state capital and largest city, has a more moderate and diverse rental market. The economy is driven by state government, healthcare, including the University of Arkansas for Medical Sciences, and multiple major hospital systems, logistics, and financial services. Little Rock's rental market offers moderate pricing power, and increases tend to be more conservative than in Northwest Arkansas. The Little Rock metro area, including North Little Rock, Conway, Benton, and Bryant, has different dynamics in different submarkets. Conway, home to 3 universities, including the University of Central Arkansas, has a student-influenced market. The western suburbs of Little Rock have attracted families seeking newer construction and quality schools. Little Rock Air Force Base near Jacksonville generates military rental demand. Military tenants' housing budgets are tied to BAH rates, and landlords near the base should monitor annual BAH adjustments when planning increases. Fort Smith, on the Oklahoma border, has a moderate and affordable rental market influenced by manufacturing, healthcare, and the University of Arkansas at Fort Smith. The market is stable but offers limited pricing power compared to Northwest Arkansas. Jonesboro, home to Arkansas State University, has a student-influenced market supplemented by healthcare and regional commerce. Pine Bluff, Texarkana, Hot Springs, and other mid-size Arkansas cities have smaller markets with moderate to limited pricing power. The Delta region of eastern Arkansas has the softest rental markets in the state. Population decline, limited economic opportunity, and low incomes constrain rental demand and pricing power in many Delta communities. Landlords in these areas need to be conservative about increases and focus on maintaining occupancy. One best practice for Arkansas landlords: because the state's legal framework is minimal, your lease agreement is your most important tool for managing rent increases. Include clear language about how rent adjustments will be handled at renewal, what notice will be provided, and what factors may influence the new rate. A well-drafted lease that addresses rent increases explicitly gives both parties certainty and reduces the potential for disputes. In a state where the statute provides virtually no guidance on rent increase procedures, the lease fills in all the gaps. Another best practice: even though Arkansas has one of the most permissive environments in the country for rent increases, approach each increase as a business decision supported by data. Research comparable rents in your specific market, track your operating costs, and time increases strategically. In Northwest Arkansas's competitive market, annual increases of 3 to 7% may be well absorbed by the market. In softer markets like Pine Bluff or the Delta region, even modest increases require careful consideration of whether the market can support them. For landlords in Northwest Arkansas, the region's rapid growth has attracted significant new apartment construction. While demand has been strong, the additional supply creates competition that can affect pricing power. Monitoring new construction activity, absorption rates, and vacancy trends helps you price your units competitively within the evolving market landscape. Arkansas's agricultural economy influences rental markets in farming communities across the state. The rice, cotton, soybean, and poultry industries employ workers who need housing. During strong commodity cycles, agricultural communities may see slightly increased demand. During weak cycles, demand softens. Landlords in agricultural communities should be aware of these dynamics. The poultry processing industry, concentrated in Northwest Arkansas and parts of Western Arkansas, employs a large immigrant and refugee workforce that represents a significant portion of the rental market in some communities. These workers need affordable housing, and landlords who serve this demographic should be realistic about what the market can bear when setting increases. For Arkansas landlords who participate in the Housing Choice Voucher Program, rent increases must be approved by the local housing authority. The authority evaluates whether the proposed rent is reasonable by comparing it to comparable unassisted units. Submit increase requests well in advance of the desired effective date. Arkansas does not have a comprehensive statutory framework for security deposit returns comparable to most states. The rules regarding deposits are governed primarily by the lease terms and common law. While this doesn't directly regulate rent increases, landlords should ensure that their lease clearly addresses both rent adjustment procedures and security deposit handling to avoid ambiguity. For the complete guide to Arkansas rent increase laws, Visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our landlord tenant law series.